Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide this case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide this case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that was properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My rulings, comments, or questions and instructions are also not evidence. It is my duty to see that the trial is conducted in accordance with the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on the race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about the following questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in this case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. When you go to the jury room, you will be provided with a copy of the final jury instructions. You should first choose a foreperson. The forepersons to see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case amongst yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations or questions about the instructions that arise during deliberations, you may submit them in writing to one of the courtroom deputies. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by the law. If you want to communicate with me while you are in the jury room, please have your foreperson write a note and give it to one of the courtroom deputies. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and a full set of instructions. If you want to look at any or all of the reference documents or exhibits that have been admitted, just ask for them. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in this case. You may consider the testimony in deciding the facts of this case. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. There has been some evidence that the defendant tried to run away, tried to hide, or actually hid after the alleged crime and the police tried to arrest him. This evidence does not prove guilt. A person may run or hide for innocent reasons such as panic, mistake, or fear. However, a person may also run or hide because of a consciousness of guilt. You must decide whether the evidence is true, and if true, whether it shows that the defendant had a guilty state of mind. You may have heard evidence that before the trial, witnesses made statements that may be inconsistent with his or her testimony here in court. You may consider an inconsistent statement made before the trial only to help you understand how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness has said in the earlier statement when determining the facts of this case. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard the stipulated facts as true, but you are not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. She only has to show that the defendant actually committed the crime and that he meant to do it. The prosecutor has introduced evidence about fingerprints. You may consider this evidence when you decide whether the prosecutor has proven beyond a reasonable doubt that the defendant was the person who committed the alleged crime. However, fingerprints matching the defendant's must have been found in the place the crime was committed under such circumstances that could only have been put there when the crime was committed. The defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts and circumstances and evidence. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard that a lawyer or a lawyer's representative may have talked to one of the witnesses. There is nothing wrong with this. A lawyer or a lawyer's representative may talk to a witness to find out what the witness knows about the case and what the witness's testimony would be. You have heard testimony from several witnesses. Dr. Leigh Lavity, who offered her opinion as an expert in the field of forensic pathology. Lieutenant Hacker as an expert in the field of latent prints. Allison Rivera Paplio as an expert in the field of forensic biology, and Sergeant Dean Molnar as expert in the area of firearms and firearm tool mark identifications. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts he or she gave for his or her opinion and whether those facts are true. You should also think about the expert's qualifications and whether his or her opinion makes sense when you think about all the other evidence in this case. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. One of the issues in this case is the identification of the defendant as the person who committed the crime. The prosecutor must prove beyond a reasonable doubt that the crime was committed and that the defendant was the person who committed it. In deciding how dependable an identification is, think about such things as how good a chance the witness had to see the offender at the time, how long the witness was watching, whether the witness had seen or known the offender before, how far away the witness was, whether the area was well lighted, and the witness's state of mind at that time. Also think about the circumstances at the time of the identification, as how much time had passed since the crime, how sure the witness was about the identification, and the witness's state of mind during the identification. You may also consider any times that the witness failed to identify the defendant or made an identification or gave a description that did not agree with his identification of the defendant during trial. You should examine the witness's identification testimony carefully. You may consider whether other evidence supports the identification, because then it may be more reliable. However, you may use the identification testimony alone to convict the defendant, as long as you believe the testimony and you find that it proves beyond a reasonable doubt that the defendant was the person who committed the crime. As to counts 1, 2, and 3, the defendant is charged with the crime of first-degree premeditated murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Alante Davis, Timothy Blanchard, and/or Paris Cameron. That is, that Alante Davis, Timothy Blanchard, and/or Paris Cameron died as a result of being shot. Second, that the defendant intended to kill Alante Davis, Timothy Blanchard, and/or Paris Cameron. Third, that this intent to kill was premeditated, that is, thought out beforehand. Fourth, that the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about and chose his actions before he did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of this case. The killing cannot be the result of a sudden impulse without thought or reflection. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. You may infer that the defendant intended to kill if he used a dangerous weapon in a way that was likely to cause death. Likewise, you may infer that the defendant intended the usual results that follow from the use of a dangerous weapon. A gun is a dangerous weapon. A dangerous weapon is an instrument that is used in a way that is likely to cause serious physical injury or death. Premeditation and deliberation may be inferred from any actions of the defendant, which shows planning, or from any other circumstances surrounding the killing. The prosecutor need not prove a motive for the killing, but you may consider evidence of motive in deciding if there was premeditation and deliberation. Motive by itself does not prove premeditation and deliberation. You've heard evidence concerning the defendant's mental condition at the time of the alleged crime. It is not enough that the defendant did an act that caused death. In addition, the defendant must have had a certain state of mind when he did that act. In deciding whether the defendant had the required state of mind, you may consider all of the circumstances surrounding the alleged crime. If you have a reasonable doubt about whether the defendant had the required state of mind at the time of the alleged crime, you must find the defendant not guilty. As to counts 4 and 5, the defendant is charged with the crime of assault with intent to murder. To prove this charge, the prosecution must prove each of the following elements beyond a reasonable doubt: that the defendant tried to physically injure another person. Second, that when the defendant committed the assault, he had the ability to cause an injury, or at least believed that he had the ability. Third, that the defendant intended to kill the person he assaulted, and the circumstances did not legally excuse or reduce the crime. As to counts 5 through 10, the defendant is also charged with a separate crime of possession of a firearm at the time he committed the crime of homicide of first degree or assault with intent to murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed the crime of homicide, first degree, and or assault with intent to murder, which has been defined for you. It is not necessary, however, that the defendant be convicted of that crime. Second, that at the time the defendant committed the crime, he knowingly carried or possessed a firearm. You will also be provided with a verdict form. At the time that you reach your verdict, you will be sending out a note to indicate to the court that a verdict has been reached. Please do not write on the note that you send out what your verdict is, just that you've reached a verdict if you're able to reach a verdict. Are the attorneys satisfied with the instructions that have been provided to the jury at this time?
Yes, Your Honor.
Yes, Your Honor.
We're going to draw lots to excuse 2 jurors. Juror in seat number 14, you are thanked and excused. I do thank you for your jury service. I thank you for appearing here timely today. At this time, you may enter the jury room and gather your belongings. I'm going to ask that once you gather your belongings, you wait in the hallway so that we can bring you your certificate and letter for your service. Okay?
The court would like to also thank you for juror in seat number 10.
Juror in seat number 10, thank you again for your service today. Please leave your notes on your chair. You may enter the jury room and gather your belongings, and please wait outside for your certificate and your letter. Swearing deputies.
Deputies, raise your right hand for me, please. Do you solemnly swear or affirm to keep this jury in the manner and form prescribed by law?
Yes.
Thank you.
Just one moment. Ladies and gentlemen of the jury, at this time, you may stand and enter the jury room. The court is sending with you a copy of the instructions as well as a verdict form, and you may begin your deliberations.
All rise for the jury, please.
Okay, Madam Prosecutor, is the computer set clean so that if the jurors request any of the video exhibits, they will be able to see them?
I just need to make one alteration to it and then I will get to work.
Is there a stipulation or something to sign off for defense counsel?
There is not, we have not had an opportunity to look at it together yet.
Okay.
Can we do that, Mr. Callahan?
Yeah, I'm good
And
with
who's
that.
going to handle where the exhibits in the event that the jury requests the exhibits, the other exhibits that were admitted aside from the video?
I have to be here.
Okay, if we can pass those forward.
I'm going to give it to Mr. Callahan first just to make sure.
Fine, that's fine. And we're off the record.
If you receive a request, just
We're off the record.